And greetings. Welcome to Maxims of Law, Part 3. We're going to be going over where we left off from last time, and at our side we'll also have Black's Law, 9th edition. So we'll make sure if there's any words that aren't clearly defined within the context, we'll make sure we leave no word behind. And let's get right down to it. We're getting into a selection of maxims of law. Of course, we're doing the English version. And let's see where we left off. Let's see here. Let's see, we're at continuation is where we are going to continue. So we have consent, construction, interpretation, and where we left off, continue. So let's continue. Let me make sure this is correct on screen. Stream health looks good if the audio is clear, and if everything on the screen is coming through good in YouTube, please let me know in the chat, and if anyone is there, we're going to continue. So, to discontinue signifies nothing else than to intermit, to disuse, to interrupt. It gains strength by continuance. That which is so persistently repeated as to constitute virtually an unbroken series is continuous. So that which is persistently repeated as to constitute virtually an unbroken series. So virtually an unbroken series. So persistently repeated, I guess, is the operative in this one here, is continuous. That is continuing, which is enduring, not terminated by a single act or fact. And that comes from Black's Law, 2nd edition. So very interesting here. These are ways to look at continuing and discontinuing as to constitute things like strength and unbroken series. So we're on to contracts. See also agree and deeds. If there is anyone out there in the chat, please let me know and say hello, and that the audio is coming through and that the video is clear. And at that point, I'm going to continue. So under contracts, we have an action cannot be founded on a barren or unconditional contract. So no action, right? No cause of action on a barren or unconditional contract. A contract is, as it were, act against act. Interesting interpretation. At that, I'll also mention that this is not to be interpreted as legal, lawful advice, professional, or personal in any way. Don't use this in any way that's not educational or entertainment, which is the purpose of this video. Don't do this at home. All right, let's continue. An obligation which arises from a contract or quasi-contract is dissolved in the same way in which it was contracted. So an obligation which arises from a contract or even a quasi-contract, distantly a contract, perhaps like agreements and such, is dissolved in the same way in which it was contracted. Words spoken vanish. Words written remain. A written contract cannot be varied by parole proof. That's your spoken proof. Interesting there. Written cannot be varied by parole. Contracts have no locality. The obligation of a contract is purely personal, and actions to enforce it may be brought anywhere. I guess that's why you can stipulate the venue for a legal remedy in the contract. A contract without consideration, or upon a false consideration, which fails, or upon unlawful consideration, cannot have any effect. The place of the contract governs the act. Interesting. Act against act, and the place governs. The place of the contract governs the act. I see here, okay. In stipulations within contracts, the time when the contract is regarded. In stipulations within contracts, the time when we contract is regarded. Private contracts or agreements cannot derogate from public law or right. Interesting there. In contracts, the truth of the matter ought to be regarded rather than the writing. Truth. Interesting here. So parole proof can't override the written word, but in contracts, the truth of the matter ought to be regarded rather than the writing. So we're getting finer and finer distinctions here. Another thing to note is private contracts or agreements cannot derogate from public law or right. So private contracts by public bodies cannot be used to circumvent the law or people's rights, apparently. Okay, the contract makes the law. That's Black's second edition. And Bouvier's 135, Allen versus Merchant Bank of New York. So there's plenty of citations here for the contract makes the law. Next. Compacts usually take their clothing from the thing itself, from words, from writing, from consent, from delivery. Contracts which are not illegal do not originate in fraud, and do not originate in fraud must in all respects be observed. All respects. Interesting. In contracts, matters of custom and usage are tacitly implied. A contract is understood to contain the customary clauses, although they are not expressed. Interesting there too. So matters of custom and usage are tacitly applied in contracts. And it's understood the customary clauses, even if they're not expressed. In writing, of course. Nice. Equal knowledge on both sides makes contracting parties equal. So, yes, full disclosure. A contract founded on a base consideration or against good morals is null and cannot be enforced by action. Contracts receive legal sanction from the agreement of the parties. So in this case, sanction meaning approval. By a contract, something is permitted, which without it could not be admitted. That's a good one there. By a contract, something is permitted, which without it could not be admitted. That which is less is held to be imported into the contract. An example, A offers to hire B's house at $600. At the same time, B offers to let it for $500. The contract is for $500. That which is less is held to be imported into the contract. Interesting there. Offers to let it for the... Okay, beautiful. The stipulations of parties constitute the law of the contract. An individual's power to contract is unlimited. The beginning and cause of every contract must be considered. Nothing is so natural as that an obligation should be dissolved by the same mode and principles in which it were contracted. Therefore, an obligation by words is taken away by words. An obligation of mere consent is dissolved by contrary consent. That's nice, very clear. A madman or lunatic can make no contract. That which bars those who have made a contract will bar their successors. Wow. A contract cannot arise out of an act radically wrong and illegal. So a contract cannot arise out of an act radically wrong and illegal. In all contracts, whether nominate or innominate, an exchange, a value, an example, a consideration, is implied in all contracts. Nudum pactum, a naked contract, is where there is no consideration except the agreement, and does not create an obligation. Interesting there too, a naked contract. In contracts, when the question is what was agreed upon, the terms are to be interpreted against the party offering them. Interesting there too. From an illegal contract, an action does not arise. In agreements, the intention of the contracting parties, rather than the words used, should be regarded. He who contracts knows, or ought to know, the quality of the person with whom he contracts. Otherwise, he is not excusable. Liberal interpretations are to be made of the deeds, so that the purpose may stand rather than fall. And every grant is to be taken more strongly against the grantor. Wow. When the words and the mind agree, there is no place for interpretation. That's from Black's second edition. An obligation without a mutual and concurrent intention of the parties, but which is implied or arising from the liability, is a quasi-contract. So it's an obligation without mutual and concurrent intention of the parties, but which is implied or arising from the liability. So I guess that's when there's a party that's has implied liability, there's a quasi-contract. Creates the obligation. A bond is released in the same manner by which it is contracted or bound. In the contract of loan, a stipulation not to be liable for fraud is not valid. So a stipulation not to be liable for fraud is not valid. So in a contract of a loan, if there's a stipulation that's not liable for fraud, then it can't be valid. It has to be liable for fraud, so it can be proven that it's valid. It's not, you can put it to the test of fraud, the authenticity of the stipulation of a loan. Okay, we're on to corrupt acts and corruption. I don't think there's anyone here, is there? Well, tell you what, we'll take off from here next time because I don't believe there's anyone here. I don't think notifications went out, and I'm talking to myself. On that note, we made it to corrupt acts and corruptions. This is where we'll take off next time. And I appreciate everyone for coming that came, if there's anyone that's here. And we'll continue these maxims next time in part 4. This has been a nice brief one, at least a little taster to get us warmed up to the idea of maxims of laws, which are the good sense of nations. And at that, thanks for being here, if there was anyone here, and I'll see you all on the next one. Peace out.